Chair Golden and Vice Chair Nash, members of the committee, for the record, Mark Owens, House District 60. We bring forward to you 3372A. This one's a tough one for me. I'm supportive. Ken and I are chief sponsors of this. But this seems to have taken a political turn that puts me against most of my ag supporters, which I typically don't do and don't really like to do. But if you look at the policy of the bill, which I'll go through, it's where I'm still a very strong supporter of it because I think it's good policy. I think it's public opinion really supports this. So in 1955, the Groundwater Code set up a domestic well policy and exemption. Basically what it says, if you have a domestic well, you need to file an application, get a start card, drill the well. And that allows you then the ability to use 15,000 gallons a day for your domestic use. Now, there's some exceptions and some limitations on that. It says you can irrigate a half acre of lawn, a half acre of non-commercial garden, and you can have 5,000 gallons for commercial activity. There's some other stuff, but we're not touching any of that other stuff in this bill. And in spring of 2024, the Water Resource Department in the Valley started enforcing those that were taking produce to farmers markets and asking them if they had a water right. I can just imagine some of those conversations. The water right? I don't know. What do you mean water right? Well, if they were found not to have a water right, what they were told they were doing was illegal and to cease and desist. Because the definition of commercial in rule does not allow irrigation. And if you inquire farther with the Water Resource Department, it talks about specifically, bear with me, commercial water use means the use of water related to the production, sale, delivery of goods, services, or commodities by a public or private entity. These uses included but are not limited to construction, operation, maintenance of commercial facilities. Examples of commercial facilities include, but are not limited to, office, resort, recreational facility, motel, hotel, gas station, kennel, store, medical facility, a veterinarian hospital. Examples of water use in such facilities include, but are not limited to, human consumption, sanitation, food processing, fire protection. Such uses shall not include irrigation or landscape maintenance of more than a half acre. Notwithstanding this definition, exempt commercial water use under Division 340 does not include irrigation or landscape maintenance. So that's the definition of why they're saying you cannot use irrigation. But I could have a resort, I could have a dog kennel, I could do a lot of things that would use up to the maximum 5,000 gallons, and that's legal. But if I decide to irrigate some cut flowers on my property and sell them, that's illegal. If I decide to have a 4-H project where my son or daughter raises something for a market and gets compensation, that's illegal. If I decide to sell something at the farmer's market, that's illegal. If I decide to trade zucchini for watermelons, that's illegal. So our office did not take this bill until 1 of 13. And the reason we did is members in my community reached out to me and said, hey, we're going to be a critical groundwater designation. They're not processing new permits. There's no way legally for us to get a water right, period. What can you do? So I said, let me look. The total amount of exempt use that's used in the state ranges between 4 and 5%. 4 to 5%. Prior to 2024, and in my anticipation, we'll stay around 4 to 5% after this. It's not, in my opinion, going to increase use. But I told my community that I'd work with this and see what we can be done. So that's what we propose to you today, is to allow 3,000 gallons of that commercial exemption to be used for irrigation. Not to exceed the 5,000. That's it. Allow that person who wants to grow their cut flowers to be able to do it. Allow that 4-H project to come along. blah, blah, blah. You know where I'm going. You're going to hear some opposition today, and we understand that. You're going to hear that this is going to tax the groundwater, that this is unfair, this not put out the same policy procedures that are required by ag. And I'll say what, you know, a lot of that is correct as far as the process and procedure, because these people aren't going to get a water right. They're just going to stop doing it. They're going to cry government overreach, and we're going to be a mess. Are we requiring these people to put in a certificate of where they're going to use the water or not? Are we requiring measuring and reporting of this water or not? Do we already require that in these other instances? No. Over half of ag, unless you're in a water district, doesn't have to measure and report. So you hear some inconsistencies. The only thing that I'll call out on those inconsistencies, which I think was not factual, is that it said we had no input with the regulated ag. So as I said, our office with Representative Helms started this conversation at 1:13. 1:15, we started having conversations with some of those that said we had no contact with them. On 2:20, we put out an email with a -2 to 52 people. Asked for comments. We got back 5 comments. We got back very little comments from those that said we had no contact with them. We took those comments and we developed the policy that we have with you forward now. So that's the only thing that I'll say is not factual in the arguments I said. The rest of it's a matter of opinion, and matter whether you think the policy is good or not, and whether there should be more sideboards on it. A yes vote on this today would allow us to go back to previously of spring of 2024.